Good afternoon, everyone. Thank you for joining us for the next in the series of Beale Company's construction law updates. This time the subject is payment, and specifically dealing with ways to tackle late payment. Just some brief introductions. My name is Will Buckby. I'm a partner at Beale Company in the projects and construction team. I'm joined by my colleague Andrew Croft, a solicitor in the team. Before we start, I would like to deal with the usual housekeeping items. This webinar is scheduled to last approximately 1 hour. During the webinar, you can submit questions to us in the appropriate box in the right-hand side of your screen. We will try to deal with these during the webinar or at the end, if time permits. Given that we have circa 150 people in attendance today, which I understand is a record for a Beale Company webinar, and which also demonstrates the importance of the issues we will be discussing, if you are able to, please can you mute your microphones. By way of a quick summary of what we aim to run through today, over the next hour, Andrew and I will be speaking about why tackling non-payment is such an important issue, your rights and obligations under the Construction Act and the Local Democracy, Economic Development and Construction Act, your client's obligations under these acts, how you might take advantage of your rights under these acts, the sort of procedures you can have in place to ensure you establish your payment rights, and welcome government plans to tackle late payment. We have chosen to speak on this subject because in recent months we have been asked to advise on this subject more and more, particularly in relation to contractors stalling payment to their supply chain, whether this be consultants or subcontractors. I think it is safe to say that it is recognised that late payment is still an industry-wide problem, despite Egan and Latham in the 90s, the Housing Grants, Construction and Regeneration Act in 1996, the Local Democracy, Economic Development and Construction Act 2009, the Department of Business, Innovation and Skills Prompt Payment Code, which in my view has no real teeth. If you haven't looked at this, it's worth a read, and I'll let you judge for yourself as to whether you think it helps with the payment process. And the recent Construction Supply Chain Charter, which various leading contractors and developers have signed up to. This commits to 30-day payment terms, but not until January 2018. So late payment is still an industry-wide problem, and this is being recognised. In November 2014, the Department of Business, Innovation and Skills, in its consultation on duty to report on payment practices and procedures, reported that between 2008 and 2012, the overall level of late payments owed to SMEs almost doubled from circa 18 billion to circa 35 billion. In the report, Matthew Hancock, Minister for State Business, Enterprise and Energy, stated that as of 2014, the overall level of late payment owed to small and medium-sized businesses is reported standing at a massive 39 billion. In January 2015, Bibby Financial Services and the Verdon Partnership, working with the National Specialist Contractors Council, reported that medium-sized building firms and specialist subcontractors are writing off 2 billion a year as bad debt. These are substantial sums. Over to Andrew.
Thank you very much, Will. So, a key player in establishing your payment rights is the Construction Act. and the Local Democracy, Economic Development and Construction Act, which amended the Housing Grants Act as from 2011. So in 1996, the Construction Act was introduced to improve cash flow in the construction industry. The Construction Act applies to domestic construction contracts, that is, except for construction contracts with a residential occupier. The key test for a residential occupier is whether or not the client is intending to occupy the project after completion. The Construction Act applies to contracts for design and other professional services which relate to construction operations as they are defined in Section 105 of the Construction Act. And those construction operations have to take place in England, Wales or Scotland. So the Construction Act does not apply to international projects. There are certain other exclusions from the Construction Act from the definition of what is construction operations, for example certain nuclear projects and drilling for oil and gas. The Construction Act provides, amongst other things, a statutory payment regime, an entitlement to suspend performance for non-payment, and a right to adjudicate. So the Housing Grants Act was revised by the Local Democracy, Economic Development and Construction Act as of the 1st of October 2011 for projects in England and Wales, and the 1st of November 2011 in Scotland. This amends the statutory payment suspension and adjudication regime in respect of all construction contracts entered into on or after that date. For example, it introduced changes to the notice requirements under the Construction Act by replacing a requirement to provide a withholding notice with the requirement for a Payless Notice, which we'll go on to shortly. The Construction Act should be your framework for obtaining payment, and for that reason we'll take you through what the Construction Act requires you to do in order to be entitled to payment. So, the Construction Act requires all construction contracts which have a specified or estimated duration of work of more than 45 days to provide for payment by instalments. It also requires all construction contracts to have an adequate mechanism for determining what payments are due and when. There are a number of implications of that, one of which is that there must always be a due date for any payment under a construction contract. In addition, all construction contracts must provide for a final date for payment for any sum which becomes due. So, in considering an appointment and calculating what the payment period will be, it's important that you're clear as to when the due date will be for any payment and when the final date for payment will be, as the final date for payment is when you will actually receive the money. Those time periods can be freely agreed by the parties in the construction contract. In addition, there's a regime under the Construction Act for providing payment notices, either by the payer or the payee, i.e. the consultant or the contractor, not less than 5 days after the due date. If the client is required to serve the payment notice under the construction contract but does not, the 2011 amendments also provide for a default payment notice to be served, either before the payment notice was required to be served by the client or after. In respect of the latter, the final date for payment will be postponed by the time period between when the client should have served its payment notice and when the default payment notice was served. So it's very important that you're clear as to what the requirements for payment notices are, and also for default payment notices, when operating a construction contract. Payment notices must specify the sum the payee considers to be due at the payment due date, and, importantly, the basis on which that is calculated. Simply stating that you consider a particular sum to be due in itself is not going to comply with the Construction Act. So how do you specify the basis on which the sum you consider to be due is calculated? Our view is that this should reflect your entitlement under the appointment. For example, by referring to any stage payments or an agreed lump sum, or if you're able to charge on an hourly rate basis, the extent of time you have incurred at the agreed hourly rate. If possible, when entering into an appointment, you should agree that your invoice is the payment notice, as if the client has the right to serve the payment notice, they essentially have two bites at the cherry, i.e. they can serve a payment notice stating that they consider £500 to be due, and then serve a Payless Notice saying that they've changed their mind and actually they consider £200 to be due. So Section 111 of the Construction Act states that the sum stated in a valid payment notice or a default notice must be paid by the final date for payment unless the payer issues a Payless Notice in the prescribed period before the final date for payment. Payless notices are very important. The prescribed period before the final date for payment will be stated in the appointment. For example, in the ACA agreement and the NEC 3 PSC, it's 7 days. In the RIBA agreement, it's 5 days. Under the scheme for construction contracts, it's 7 days, and that will apply if your appointment does not say what the prescribed period is. A Payless Notice must specify the sum the client considers to be due on the date it's served and the basis on which that sum is calculated. And it's important to note that Payless Notice is required even if the amount considered due is zero. If no Payless Notice is issued, or it's issued late or invalid, the paying party must pay the notified sum in the payment notice or the default notice by the final date for payment. So, a withholding notice is unlikely to be a valid Payless Notice, because simply stating the sum considered to be due is unlikely to suffice. Going back to the requirements for a Payless Notice, you have to say the sum considered to be due and the basis on which that sum is calculated. In addition, if no reasons are given for any deduction in the Payless Notice, it's unlikely to comply with the Construction Act. You should be on your guard and prepared for any Payless Notice to be issued and prepared to act if it's not issued on time. Even if a Payless Notice is issued, the sum stated as due in the Payless Notice is still required to be paid by the final date for payment, so it's important that you chase that. In our view, a lot of parties in the construction industry fail to comply with the requirements of a Payless Notice. So if you're able to respond to any such failure swiftly and strongly, you're likely to increase your chances of payment significantly. And this is an example of the payment process under the Construction Act. So just taking you through the slide. At the start of the payment process, which you might call day one, the payee in this case issues an invoice or a payment, which is also a payment notice. That invoice is due on day 7, and that's the payment due date. The final date for payment is 21 days after the invoice is issued. The prescribed period in which the Payless Notice must be issued is 7 days before the final date for payment, so the Payless Notice must be issued 14 days after the invoice. If the client doesn't issue a Payless Notice, they must pay the sum in the invoice. If the client does issue the Payless Notice, they must pay the amount in the Payless Notice.
Thank you, Andrew. In considering how to tackle late or non-payment, it is important that the party expecting to receive payment is aware of the mechanisms in the Construction Act as amended by the LD-EDC Act, which can be used as sticks to getting paid. By Section 112, if an amount due is not paid fully by the final date for payment, and this can include a lesser amount due pursuant to a valid Payless Notice issued by the client, as Andrew has mentioned, the payee has a right, without prejudice to any other right or remedy, to suspend performance of any or all of its obligations under the contract. The right to suspend may only be exercised if a notice of intention to suspend, stating the ground or grounds on which the payee intends to suspend performance, is provided to the defaulting party 7 days before suspension. Note that the right to suspend will cease immediately upon payment of the full sum being made. Where suspension is made, the defaulting party is required to pay a reasonable amount in respect of costs and expenses reasonably incurred by that party as a result of the suspension. Further, the period during which suspension takes place is disregarded in computing the contractual time limit under the project or contract vis-à-vis the performance of the payee. We advise our clients that in any letter where there's non-payment and suspension is threatened, to remind the client's employer of these rights. They can be quite useful. However, a word of warning: the payee must be very careful if it is looking to suspend. Wrongful suspension could result in repudiatory breach, and any notice must precisely comply with the requirements of the Act and the appointment to be successful. To this end, our view is that legal advice should always be sought in the event that a threat or right to suspend is going to be exercised, given the risk of serving an incorrect notice or making a wrongful threat. There are, of course, other sticks for obtaining payment. The next couple sticks that I wish to talk about are more practical points and do not necessarily arise directly out of the Construction Act. In providing its services, the consultant is likely to provide a copyright license or transfer its IPR to its client. Some consultants' appointments, certainly not all of them, entitle the consultant to revoke its copyright license in the event that payment is not made. Such drafting is included in the REBA and ACE forms. A threat to revoke copyright could result in payment being forthcoming. We have advised a client on such an approach recently, which fortunately resulted in payment. Where there is no appointment in place, or the IPR provisions are limited or non-existent, the general view is that it is unlikely that the payee will have a right to revoke the license unless the failure to make payment constitutes a repudiatory breach, which I think itself is highly unlikely. In Deakin and another, trading as Faith Image Source and Card Racks, a 2011 case, it was held that failure to make payment gave rise to a debt rather than a repudiatory breach. Although this is not a construction case, it suggests that non-payment will not entitle a consultant to revoke a copyright license unless expressly permitted to do so in the appointment. A further stick to obtaining payment is perhaps in the circumstance where additional services have been carried out and not yet invoiced, perhaps as a mere goodwill gesture to the client, or for whatever reason that the payee has decided not to invoice for the additional services. A threat to invoice the additional services if outstanding payment hasn't been made within the required timescale may result in payment being forthcoming. We've seen this happen in practice. There, of course, is always adjudication, which can be used as a tool to obtain payments. Generally, adjudication was introduced by the Construction Act in order to allow for a quick and cost-effective means for resolving payment issues in the construction industry. The Act provides at Section 108 that any party to a construction contract can refer a dispute arising under the contract to adjudication under a procedure which complies with the Act. Now, the Act requires any construction contract to enable a party to give notice any time of its intention to refer a dispute to adjudication. It requires a construction contract to provide a timetable with the object of securing the appointment of the adjudicator and referral of the dispute to him within 7 days of such notice. The construction contract must require the adjudicator to reach a decision within 28 days of referral or such longer period as is agreed by the parties after the dispute has been referred, and it must allow for the adjudicator to extend the period of 28 days by up to 14 days with the consent of the party to whom the dispute was referred. The decision of the adjudicator will be binding until the dispute is finally determined by legal proceedings, by arbitration, as the case may be, or by agreement. Our advice is typically that adjudication is an excellent tool in order to get a quick and cost-effective decision, I suppose in comparison to litigation and arbitration. It does have its limitations, which must be borne in mind by its users, whereas in litigation and arbitration, legal costs tend to follow the award, and a successful party can recover its legal costs and expenses. Each party generally bears its own costs in adjudication, which could be a put-off. Given the quick nature of the process and that adjudicators can vary, there is a risk of what some say is rough justice. And in order to rely on adjudicator's decision, the successful party may have to enforce a decision in the courts, incurring time and cost in doing so. Although the TCC generally follows an adjudicator's decision, and this is becoming increasingly common in the reported cases. There are some other considerations to look at when tackling non-payment. Section 113 of the Act provides that provisions which make payment conditional on the client receiving payment from a third party are ineffective. There is an insolvency exception. Pay when paid drafting is permitted if it relates to the client's insolvency In these circumstances, drafting can allow the payee not to make payment to its supply chain. There's also section 110, subsection 1A, which was introduced by the LD-EDC Act. This provides that making payment conditional on the performance of obligations under another contract or on a decision as to whether obligations under another contract have been performed are also ineffective. In practice, this means, for example, that any provision in an appointment which makes payment conditional on it being certified under, say, the head contract is unlawful. Payees should look out for such provisions in negotiating their UK contracts and seek to remove such drafting. Andrew is going to come on to some front-end issues further in this talk. Employers also, as I'm sure you will know, operate payment on this basis, notwithstanding any drafting, which is Act compliant. So payees should also look out for this conduct and stamp it out as quickly as possible. There's been very limited case law on the recent changes to the Construction Act as introduced by the LD-EDC Act. One case we thought would be helpful to mention is what I think is the first case on the LD-EDC Act. And the case is ICG Construction and Civic College. It's a 2014 case in the TCC. The case provides an interesting insight into the court's current view as to the importance of providing payment notices as required by the Act. We thought it'd be helpful to run you through the facts and to quickly summarise the judge's decision. So ICG was appointed as a design and build contractor under the JCT Design and Build Contract 2011 by Civic College. It was amended, as is usually the case, but the payment terms of the contract were Construction Act compliant. ICG submitted its interim application for payment at number 13 in the sum of just over 1 million. As no payment was forthcoming and Civic College failed to serve either a payment notice or a payless notice in time, ICG commenced adjudication in respect of the £1 million sum. 4 days prior to the adjudicator's decision, Civic served a notice of adjudication for determination of the correct value of the works as at the date of application number 13. So a second adjudication commenced. The adjudicator found in favour of ICG regarding the first adjudication, largely because Civic did not issue a payment notice or payless notice in accordance with the contract. However, the same adjudicator deciding on the second adjudication, i.e. the value of the works, he valued the works at only circa 300,000, so a stark reduction to the near 1 million awarded in the first adjudication. Next, ICG sought summary judgment for enforcement of the decision in the first adjudication and a declaration that the second adjudication was invalid for want of jurisdiction, the matters being the same or substantially the same as those already decided under the first adjudication. So what did the court hold? Mr. Justice Edward Stewart, he found in favour of ICG. In his decision, Mr. Justice Edward Stewart stated, if the employer fails to serve any notices in time, it must be taken to be agreeing the value stated in the application. He also commented, and this is what is stated on the slide in front of you, the statutory regime would be completely undermined if an employer, having failed to issue the necessary payment or payless notice, could refer to adjudication the question of the value of the contractor's work at the time of the interim application. This is quite an important decision. The court held, obviously, that the first adjudicator decide the value of the work for the purposes of the interim application, and that the second adjudication was redundant. It's quite comforting. It suggests that an adjudicator and the court should make a favourable decision for the payee in circumstances where employers do not issue the required notice that Andrew has described. Further, this case also shows the benefits of reacting quickly to any failure by an employer to serve a payless notice in time, as this could entitle the contractor or consultant to adjudicate in relation to the employer's failure to do so, without the adjudicator considering any allegations the employer may have regarding the sum claimed in the payment notice.
So I'm now going to take you through the key things you should bear in mind when negotiating appointments to ensure that you can take advantage of your rights under the Construction Act. The first thing, as I commented on earlier, wherever possible, you should request that your invoice is stated to be the payment notice. And that's a position under a lot of the standard form appointments, including the RBA appointment and the ACE appointment. By doing that, you have control over the payment process, as in you fire the first shot, essentially. Whereas, as I was saying, if the employer issues a payment notice, they have 2 bites of the cherry. In addition, it is fairly common for the due date for any payment to be the date on which an invoice is issued or the date on which it's received. And you should avoid any longer time period which will merely delay your entitlement to payment. It is also important that you're clear as to when the final date for payment will be, and that should be a reasonable time after the due date. For example, 28 days might be a reasonable time, but that might depend on your particular commercial arrangements and the project. To the extent that an appointment or any other construction contract does not comply with the Construction Act or the 2011 amendments, the scheme for construction contracts is likely to apply. The scheme for construction contracts is intended to protect those receiving payment in the construction industry, but it's a complex document and it's not particularly easy to apply to any particular project. For that reason, if an appointment does not comply with the Construction Act, that will create uncertainty as to what your rights are and will make it more difficult for you to recover payment. And it's very likely that you'll be required to take legal advice as to exactly when the payment due dates are under your appointment. For that reason, you should ensure that any appointment you enter into does comply with the Construction Act and the 2011 amendments. Something which seems to be very common in the industry at the moment is requirements which don't necessarily fall foul of the Construction Act in word, but require the consultant or the contractor to do a lot more than the Construction Act does. And so it might be arguable that they're not quite in the spirit of the Construction Act. And a lot of large contractors have these sorts of things in their standard forms of appointment at the moment. For example, there might be conditions precedent to payment. These can range from providing collateral warranties within 7 days of a request to something which is perhaps more extreme, to attending all site meetings before you can receive your final payment, and an appointment in front of me has got such an obligation in it at the moment. Something else which you should try and avoid if possible are very detailed or really onerous invoicing requirements, and that might include a requirement for you to maintain very detailed open book accounting. For example, another appointment which I am currently looking at contains a requirement for any payment notice to include wording in writing containing a heading in red capitals which states that this is a payee notice, amongst other things. The risk with such requirements is that for something which is not necessarily easily manageable, you could lose your rights to payment on a project. It might be arguable in certain appointments that such requirements are not actually in line with the Construction Act, but that I would not personally want to rely on that. If I see appointments with those sort of requirements in them, you should try and strike them out wherever possible. If you can't strike them out and they are manageable, you need to make sure that you comply with those requirements during the course of the project, and that you have the right procedures in place to make sure that your invoicing department knows what they need to do when they issue invoices, for example. Something else to bear in mind, which might increase your rights to payment or your ability to receive payment, are the project bank accounts. These are increasingly being used on government projects and essentially involve the employer paying a sum into a central bank account from which payments to the Tier 1 and Tier 2 suppliers, and sometimes even further below that, are directly made following certified applications. And that's something that you could try and seek if you have concerns about any particular employer. So, moving from the start of a project when you're considering an appointment to the other side when a payment hasn't been made on time, or during the course of a project even, you should consider revising your standard invoices to ensure that they meet the statutory requirements, i.e. the requirements under the Construction Act. For example, this might be by making sure that all invoices clearly state the sum considered to be due and the basis on which that is calculated, or it could be something which is fairly simple and straightforward, such as including a statement at the bottom of your invoice that the invoice is a payment notice. The latter is not necessarily going to be decisive if there was a dispute as to whether an invoice was a payment notice, but it's certainly going to be persuasive, and it will help you argue with your client that your invoice was the payment notice. It's also important that during the course of the project you have clear processes in place for tracking when invoices are issued, and also when those invoices become payable. The reason to do so is that this will help you to take prompt action if the client fails to issue a notice in time or simply has not paid in time. And you should also consider Payless Notice issued by your client very carefully and be prepared to take action if you consider that the Payless Notice they've issued is not compliant with the Construction Act, or if it's late. One thing which we advise a lot of our clients is to have a clear decision tree in place so that you can take steps to recover late payments, whereby you have a tiered or escalated approach in relation to correspondence following a late payment. And this can range from perhaps initially sending a credit control letter or a number of credit control letters to a firm email or letter which might be copied to your lawyer, to even getting your lawyers involved, or at the top of the tree might be taking formal legal proceedings to recover the outstanding sums. As Will was discussing previously, there are risks associated with exercising some of the rights under the Construction Act, in particular suspending performance and adjudicating. So it's important that you take legal advice before going ahead with that to make sure that you have actually got the right to do so. So there is currently a lot of consultation in process in relation to late payment. For example, between November 2014 and February 2015, the government consulted on large companies being required to publish on their website their payment processes and procedures, including the average length of time it takes them to pay their invoices, the proportion of invoices not paid on time, and the proportion of invoices paid in 30, 60, 120 and more than 120 days. They're also considering requiring companies to publish their standard and maximum payment terms on their websites every quarter. Under the proposals, there is not a statutory requirement to pay invoices on time or within a certain period, but there is a right, or is a fine, if the company does not publish the payment report. Hopefully, if that requirement is introduced, it will incentivize companies to make payment on time in order to uphold their reputation. The regulations are due to be brought in under legislation which is due to come into force later this year, and it's not entirely clear what the timescale for that being brought in is, but it's certainly a positive step. In addition, the government is currently consulting on plans to give trade bodies the power to challenge grossly unfair payment terms in the courts. It's unclear exactly who will fall within the definition of a trade body under the proposals, although trade bodies are able to speak to the government now and request that they are including in a proposed list of trade bodies. And it's also not entirely clear what will be included within the definition of grossly unfair, but it's likely that this will be more than just a payment period which is longer than 60 days, which is the current definition, but it might be something along the lines of the legislation in Ireland. So these are just a few of the positive proposals that are out there at the moment. So it's important to watch this space, and hopefully the payment culture will improve over the next few years.
Thank you, Andrew. So that has been a quick summary of some of the steps you can take to tackle late or non-payment. We hope it has been useful. If there are any points to take away with you following this webinar today, we believe it's important that you know your rights under the Construction Act and the LD-EDC Act. Debt collection is at the heart of any construction practice, whether it be a professional or consultant, and the Construction Act and LD-EDC Act can greatly help recover money. We believe it's important that you are prepared to respond and deal with your client in the event that they do not comply with their payment obligations in your appointment or as prescribed by the Act. We hope that you might have a look at your own internal procedures to check that they are Act compliant and that they allow you to manage invoicing and debt recovery. At the front end of things, we hope that you'll be able to focus on negotiating an acceptable appointment as far as payment terms are concerned, and now look out for provisions which may not be Act compliant, and push for the removal of any onerous conditions precedent or detailed invoicing requirements which may be used by your client as a means to stop payment or make payment being more difficult. We are seeing this more and more on contractors appointing consultants. In our view, much of the drafting is against the spirit of the Act, and it is for consultants to negotiate hard against their contractor client to avoid these detailed and complex payment provisions. We also advise not to be afraid and to turn up the heat if you're not being paid. We would say this as lawyers, and this can greatly help in encouraging payment. Please do not let us know if you would like help on any of the issues, matters that we've discussed today, including in relation to outstanding fees or looking at your own internal procedures. We have received quite a lot of questions. Andrew and I have answered these where we can throughout the webinar. It's the benefits of having two of us do the talking. There are a number of questions which we would like to respond to you direct, and we will do so. We will also circulate a copy of the slides. My colleague Stephen Milne is also writing an article on the ISG case, which will be in construction law shortly, and if you don't mind, we will circulate this to you as well. But before we finish, you might be aware that our next webinar will be on the 25th of February at 12:30 on the Draft Construction Design and Management Regulations 2015 and the proposed changes and what they'll mean to you. Further details are provided on the slide. This will be delivered by my partner Sheena Sood and also Andrew again. So that's on the 25th of February. If you haven't received an invite and are interested in attending, please do not hesitate to contact us. It remains for me to say thank you very much for listening to me and Andrew this afternoon. As I say, if you do have any queries in relation to the issues we have discussed, please do not hesitate to contact us on the details shown on the screen. Once again, thank you for listening, and we look forward to seeing you on our next webinar.